involved the wrongful, corrupt exercise of presidential power, and many of which were likely not statutory crimes. In explaining its second article, the House Judiciary Committee stated that President Nixon's conduct was undertaken for his personal political advantage and not in furtherance of any valid national policy objective. That should sound familiar to everyone here. It reflects a standard I've already articulated: the exercise of official power to corruptly obtain a personal benefit while ignoring or injuring the national interest. To be sure, all presidents account to some extent for how their decisions in office may affect their political prospects. The Constitution does not forbid that. Elected officials can and should care about how voters will react to their decisions. They will often care about whether their decisions make it more likely that they will be reelected. But there is a difference that matters between political calculus and outright corruption. Some uses of presidential power are so outrageous, so obviously improper, that if they are undertaken for a president's own personal gain, with injury or indifference to core national interests, then they are obviously high crimes and misdemeanors. Otherwise, even the most egregious wrongdoing could be justified as disagreement over policy or politics, and corruption that would have shocked the framers, that they expressly sought to prohibit, would overcome the protections they established for our benefit. And there should be nothing surprising about impeaching a president for using his power with corrupt motives. The House and Senate have confirmed this point in prior impeachments. More important, the Constitution itself says that we can do so. To start, the Constitution requires that the president faithfully execute the law. A president who acts with corrupt motives, putting himself above country, has acted faithlessly, not faithfully executed the laws. Moreover, the two impeachable offenses that the Constitution enumerates, treason and bribery, each require proof of the president's mental state. For treason, he must have acted with a disloyal mind, according to the Supreme Court. And it is well established that the elements of bribery include corrupt motives. In sum, to the framers, it was dangerous for officials to exceed their constitutional power. But it was equally dangerous, perhaps more so, for officials to use their power with corrupt, nefarious motives, thus perverting public trust for private gain. Abuse of power is clearly an impeachable offense under the Constitution. To be honest, this should not be a controversial statement. I find it amazing that the president rejects it, yet he does. He insists that there is no such thing as impeachable abuse of power. This position is dead wrong. All prior impeachments considered of high office have always included abuse of power. All of the experts who testified before the House Judiciary Committee, including those called by the Republicans, agreed that abuse of power is a high crime and misdemeanor. Here is testimony from Professor Pam Carlin of Stanford Law School, joined by Professor Gerhard.
Do scholars of impeachment generally agree that abuse of power is an impeachable offense?
Yes, they do.
Professor Gerhard, do you agree that abuse of power is impeachable?
Yes, sir.
Professor Turley, who testified at Republican invitation, echoed that view. In fact, he not only agreed, but he, quote, stressed that it is possible to establish a case for impeachment based on a non-criminal allegation of abuse of power. Professor Turley is hardly the only legal expert to take that view. Another who comes to mind is Professor Alan Dershowitz, at least Alan Dershowitz in 1998. Back then, here is what he had to say about impeachment for abuse of power.
It certainly doesn't have to be a crime. If you have somebody who completely corrupts the office of president and who abuses trust and who poses great danger to our liberty, you don't need a technical crime.
But we need not look to 1998 to find one of President Trump's key allies espousing this view. Consider the comments of our current Attorney General, William Barr, a man known for his extraordinarily expansive view of executive power. In Attorney General Barr's view, as expressed about 18 months ago, presidents cannot be indicted or criminally investigated. But that's okay, because they can be impeached. That's the safeguard. And in an impeachment, Attorney General Barr added, the president is answerable for any abuses of discretion and may be held accountable under law for his misdeeds in office. In other words, Attorney General Barr, who believes, along with the Office of Legal Counsel, that a president may not be indicted, believes that that's okay. We don't need that safeguard
Man,
against
that's bullshit.